So now it's my pleasure to introduce our presenter today, Mr. Michael Pakter. Michael has more than 40 years of experience in forensic accounting, investigations, and litigation services in numerous industries and diverse engagements, including more than 20 years of experience in economic damages and business valuations. State, federal, and bankruptcy courts, as well as arbitrators, have recognized him as an expert in forensic accounting, economic damages, business valuation, CPA malpractice, and bankruptcy court proceedings. He is a CPA with multiple additional certifications in economic damages, financial forensics, business valuation, and bankruptcy court proceedings. Mr. Michael Pakter.
Thank you. Good afternoon, everybody, from a pleasant Chicago afternoon. I'm here to talk about the new Subchapter V Small Business Bankruptcy Process. I hope you can see my slides. Besides the slides, I actually provided a copy of the new Bankruptcy Code, Subchapter V. The Small Business Reorganization Act was passed by Congress in August of 2019 and became effective in February 2020. And the Small Business Reorganization Act of 2019 is also called the SBRA. And within that, it created a new Subchapter 5 of Chapter 11 of the Federal Bankruptcy Code for small business debtors. The SBRA was effective February 19th, 2020 for cases filed on and after that date. When the SBRA was signed into law, I don't think that anybody could have foreseen how it would be used and its very urgent need during the course of the novel coronavirus pandemic. Some people think that this act was passed in response to the pandemic. It was not. It was slightly amended and edited as a result of the pandemic, but this amendment was already, SBRA was already in process beforehand. So Subchapter 5 has streamlined the reorganization process for debtors with less than $2,725,625 of debt. Go figure how Congress got to that number. I do not. So Subchapter 5 streamlined the reorganization process for debtors with less than that dollar amount of debt by eliminating certain disclosure and solicitation obligations and by tightening the case deadlines to ensure that the Subchapter 5 was a quick trip through the bankruptcy process. The pandemic has hit small businesses especially hard, and Subchapter 5 might be a much needed lifeboat to help many small businesses survive. Now, the CARES Act, which was a pandemic response litigation, the Coronavirus Aid, Relief, and Economic Securities Act, that was passed in late March 2020, in response to the pandemic, raised that debt cap from $2.7 million and change to $7.5 million, but only for a limited time, in an effort to help companies struggling in light of the current widespread business shutdown. So that cap, currently of $7.5 million, will go back to the approximately $2.7 million after 1 year, unless it's renewed by Congress. And so that cap will go back from 7.5 million to 2.7 million in approximately March of 2021. Under the SBRA, a small business debtor can now elect to have its case administered under Subchapter 5. Absent such an election, the small business case continues to be administered under Chapter 11 of the Bankruptcy Code. If the debtor's primary business interest or activities owning a single asset real estate, the debtor cannot be considered a small business debtor. So this subchapter 5 will not apply to small single asset real estate entities. If the SBRA didn't apply, then Chapter 11 of the Bankruptcy Code probably would have been too complicated and or too expensive for small businesses to have used it currently. And that was the purpose of coming up with the new Subchapter 5, so that companies would be able, for small businesses to be able to work out with their creditors without a super expensive and or complicated trip through Chapter 11. The principal changes for Chapter 11, Subchapter 5 cases are that the trustee will be appointed in every case to perform a variety of duties, but the debtor will continue to retain control of its assets and operations. So like in a regular Chapter 11 case, the debtor will be debtor in possession, but unlike a regular Chapter 11 case, there will be a chapter trustee. Normally, a trustee is only appointed for cause in a Chapter 11 case. There will be no creditors committee appointed unless the Bankruptcy Court orders one appointed for cause. All of this is in part to keep things moving, to reduce administrative costs, to make the Chapter 11 process simpler and easier. Again, this is not a Chapter 7. This is not a liquidation. This is a reorganization of a small business. There will be no quarterly US Trustee fees in the Subchapter 5 case, and the plan of reorganization must be filed within 90 days after the order of relief. Again, the court has the right to extend that time period if they meet certain criteria and with notice. But basically, the Bankruptcy Court, the US Trustee, and the Subchapter 5 Trustee want this to move through the court system very quickly. Only the debtor may file a plan of reorganization, unlike a regular Chapter 11 where the debtor has a period where only the debtor can file a plan of reorganization, and thereafter anybody can file a plan of reorganization, and there can be competing plans in a non-small business Chapter 11 reorganization, and there doesn't seem to obviously be the provision for others besides the debtor to file this plan of reorganization. Absent an order of the Bankruptcy Court, no disclosure statement will need to go with the plan of reorganization, which is very expensive for attorneys and their analysts to prepare. And the plan of reorganization still has to have certain basic disclosures, but it does not need a full disclosure statement under Chapter 11. The reorganization plan can address the debtor's principal residence in certain circumstances, and that is a slight complication. And debtors whose principal residences are or are not secured or are involved in the debt may find, after some analysis, depending on the facts and circumstances, that a Subchapter 5 is more or less favorable than a Chapter 11 because of the ability to deal with the debtor's principal residence as part of the plan. if all impaired classes vote to accept the plan of reorganization, confirmation will be considered consensual. In other words, the debtor and the creditors will be deemed all to have agreed, and there will be three consequences. Claims will be discharged upon confirmation. The trustees' services will be determined when the plan of reorganization is substantially consummated, and the reorganized debtor is responsible for making payments to the creditors pursuant to the terms of the plan of reorganization.
Michael,
Yes.
you have a question. Is the deadline for filing claims by a governmental unit shortened in a sub V case, generally 180 days? However, a sub 5 plan of reorganization is required within 90 days.
I can answer that question that the plan of reorganization is required within 90 days unless the court extends that. I do not know if that will amend the governmental entity's service rights or notice. If the person will please email me at mpakter@litcpa.com, I will get them an answer. mpakter@litcpa.com. I'm happy to get that answered for them. Also, I collected a lot of materials in preparing for today's PowerPoints. The PowerPoint is a summary of summaries. If anybody would like copies of the additional materials that I went and researched, I do have a file folder, and I can either send that in emails or a Dropbox, and I would be happy to do so. Again, mpakter@litcpa.com. If all the impaired classes vote to accept the plan of reorganization, confirmation will be considered consensual, and there will be the three consequences that I talked about. Unlike a traditional Chapter 11 case, where the administrative expenses must be paid at the time of confirming the plan of reorganization, the Subchapter 5 allows the administrative expenses to be paid over the life of the plan. That may or may not help the debtor or the creditors or the US or the Subchapter 5 trustee appoint analysts, accountants, valuators, or analysts to assist with the process. The debts of the debtor are not considered discharged until the debtor completes all of its planned payments. All of the payments it promised to pay under the plan of reorganization have to be paid before they can be discharged. Now, one of the questions I routinely get asked is, will there or will not there be work for NACVA analysts as part of the process? The US Trustee that I called said that the US Trustee's office contemplates that analysts or valuation people will not be needed. The Subchapter 5 trustee that I spoke to said he sees the possibility for there to be a valuation if the debtor's asset includes a interest in another entity and is still within the level of debt provided, in which case the Subchapter 5 trustee told me he may be prepared in certain circumstances to first obtain an oral opinion of value provided he could mediate between the parties. But he also said that it would not be impossible to get a calculation letter in these circumstances versus a full opinion of value. These matters are all up in the air. These are just the opinions of some people that I called. There's no, to my knowledge, law, common law, or decided cases just yet on any of the things that I'm currently talking about. Again, if you have questions on any of these, please let me know. I'd be happy to answer. One of the changes introduced by the Subchapter V is that the creditor's ability to block confirmation of the plan by rejecting the plan is much weaker. What's known as the absolute priority rule is abrogated. And if one or more impaired classes do not accept the plan of reorganization, then the Bankruptcy Court can still confirm it on a non-consensual basis, so long as the court finds that the plan does not discriminate unfairly, and so long as the court finds that the plan of reorganization is fair and equitable with respect to each impaired class of claims or interests that have not accepted the plan of reorganization. So anecdotally, I'm to understand that the bankruptcy courts have been and are likely to be very debtor friendly in the Subchapter V cases. And so creditors who dissent for unreasonable reasons are probably not going to find that the court hears their unreasonable claims. The US Trustee is going to appoint a trustee for each Subchapter V case. I know that in the Northern District of Illinois, there are currently 4 Subchapter V trustees. One I know and have never worked with, one I know and have worked with a great deal on many cases. I also, in preparing for today, have had discussions with one of the US trustee who didn't, none of these people wanted to be named or be on the record right now because this is currently new. So normally a Chapter 11 trustee is appointed only for cause in a Chapter 11 case. Here, the Subchapter V trustee has the authority to investigate wrongdoing or do other things that a Chapter 11 trustee would do. But in practice, I'm to understand that the primary function of the Subchapter V trustee is to facilitate a consensual plan between the debtor and its creditors. This is tantamount to a mediator in a litigation settlement. The Subchapter V trustee that I spoke to says that he will try as far as possible to mediate any disputes between the debtors and the creditors. And the US trustee that I spoke to said they would not find that objectionable so long as it was transparent and done with nothing unethical. The US trustee monitors and supervises all Chapter V trustees and cases. To the best of my understanding, there are now 250 Subchapter V trustees throughout the federal districts in the US. As I said, in Federal District of Northern District of Illinois, which is essentially Chicago, there are currently 4. Those, the US trustee is still going to do the initial debtor interview. The US trustee is still going to review the monthly operating reports. Assumedly, there may be only 3 or 4 of those given that the plan should be done, and this contemplates a 3-month turnaround. The US trustee, and please make a difference between the US trustee and the Chapter 11, Subchapter 5 trustee. The US trustee would seek to convert or dismiss the Subchapter 5 cases or remove a debtor in possession and put the trustee in possession if needed. So if the US trustee sees that the debtor is playing games, not being honest, it will convert the Subchapter 5 trustee to a trustee in possession, same as in a Chapter 11. The US trustee has been reviewing applications by the debtor to retain professionals. They will still review the fee applications and the compensation requests of the Subchapter 5 trustees and any other professionals that might be appointed. As more US companies tip into bankruptcy, the Subchapter 5 rules are intended to provide a better and a faster and a cheaper path to reorganization than was previously available to small businesses. This cheaper, faster, and more efficient Subchapter 5 process might allow small businesses that previously could not have financed a Chapter 11 case to be salvaged by having a plan of reorganization, excuse the typo, by completing a Chapter 11 case. One of the issues in a Chapter 11 case is increasingly the complexity and the cost and the need for the creditors committees and the need for constant court appearances and the length of the disclosure statement. For those who've attended my full-day bankruptcy class, we went through and showed the hundreds and hundreds and hundreds of pages of the United Airlines plan of reorganization and disclosure document. And I understand that isn't the disclosures that are needed in a much smaller case. But still, Chapter 11 is complicated, can take a long time. Creditors committees usually tend to appoint experts. The debtor tends to appoint experts. Sometimes the US trustee needs to get more involved. All sorts of litigation happens regarding preferences and fraudulent transfers. And it's just not a very cheap, fast, or efficient process for a smaller company. So the cheaper, faster, and more efficient Subchapter 5 process hopefully will allow companies that previously could not have financed a Chapter 11 case to be salvaged by having the plan of reorganization. The other advantages of the Subchapter 5 case is that it will allow the debtor to spread its debts, usually over a 3 to 5 year period. And that spread of the debts would also enable the administrative costs to be dealt with. That would allow the fees paid to the Subchapter 5 trustee to be spread out over time, though probably Subchapter 5 trustees will want to have their administrative fees paid through the fee application earlier on, but it does allow payment over time. And those payments over time require the debtor to devote its projected disposable income to pay the creditors. So perhaps there is, after all, a role for professionals in order to come up with projections over time of disposable income. Maybe the debtor is not able to do future projections. Maybe it will be necessary to have analysts do projections. And it is also entirely possible that the Subchapter V trustee may want to have professionals in order to come up with these projections. It is currently an open question whether this will or will not create more work for analysts. So a key question now might become, what is going to determine the outcome and the success of a Subchapter V case? Some people have told me that the key to success might be the talents of the Subchapter V trustee. So I know that the US Trustee was very selective in choosing the Subchapter V trustees. The one Subchapter V trustee that I know has an extreme years and years of experience, both as a lender, financier, bankruptcy lawyer, and Chapter 11 trustee. He has also served as a receiver, an examiner. He has hired valuation experts. He has hired forensic accountants. He has hired lawyers. He has hired specialist engineers. And I know him to have a very well-rounded set of talents that would probably be really good in resolving a Subchapter V trustee case. So as a Subchapter V trustee, he, like other Subchapter V trustees, have the authority to investigate the debtor's financial affairs. So there could still be questions about preferences, fraudulent conveyances. There could be questions about reviewing the general ledger and the prior bank accounts of the debtor to see how much personal, non-business expenses may have gone through the accounting books and records. If the small business owner was making disbursements of a non-business type, it is possible that they would, they could ask, the Subchapter V trustee could ask for a contribution back. It is possible that the creditors will only agree to discharge some of their debts if, in fact, some of that money is paid back. So the Subchapter V trustee does have the authority to go back and investigate the debtor's financial affairs. But again, their primary function is to facilitate a consensual plan of reorganization between the debtor and its creditors. There is also the chance that the skills, experience, and talents of the Subchapter V trustee would increase the chances of a fair and equitable resolution between the debtor and its creditors. So I can see in pure hypothetical theory that the Subchapter V trustee could push the debtor to come up with better payments over time, or to improve their projections, or get fresh injections of equity. I can also see the possibility that fresh lenders step in and they also come up with additional injections of liquidity, perhaps on a secured basis that wouldn't be achieved before. So it is possible that the Subchapter 5 trustee will, bash heads on both sides to get people to a negotiating table. I was told of an interesting circumstance regarding a certain unscrupulous lenders. And if you remember, the debt limit for a small business reorganization case was approximately $2.7 million. And I've come across an instance where the lenders, the creditors, the bank, insisted on only lending a $3 million amount and would not lend less. And it is possible that the lender could have been wanting to avoid the use of Subchapter 5 in any future bankruptcy. That won't matter right now because the limit is temporarily increased through the pandemic litigation to $7 million. But debtors need to beware of unscrupulous lenders, and there have been examples, who have structured the loans to the debtor in amounts and or with other conditions that have precluded the use of the Subchapter 5 process. The new small business bankruptcy process might be useful for small businesses whose creditors are unwilling to make reasonable concessions in the light of the current business environment. And the uses and value of the Subchapter 5 bankruptcy process is becoming increasingly important as this pandemic seems to be never-ending. Anecdotally, as I said before, it appears that bankruptcy courts are being very debtor-friendly, and that might be an additional incentive for the creditors and the Subchapter 5 trustee to work together. And clearly it should be in the interests of creditors to enable this debtor to continue and to continue in business and continue to employ people and to remain alive. So that concludes my prepared remarks. We still have 10 to 15 minutes, and I hope I will be able to take questions, and I deliberately did not overload the presentation so as to be able to take questions.
Okay, if anyone wants to ask questions, the Q&A is open. If you would like to use the chat, you're more than welcome to do that as well. So Michael, you have supplemental items that you talked about, maybe?
Right. So if there are no questions, I did prepare a supplement, which I'm putting up on the screen. This also should have been provided to participants. Wendy, please let me know if you can actually see the act.
I can see it, and we do have a question.
Okay.
Do you feel that secured creditors have less power in Subchapter 5 versus Chapter 11?
Great question. Facts and circumstances will ultimately dictate, but I think the secured creditors will still have the power that they have because you're still going to follow the Bankruptcy Code. And I think in that circumstances, you're going to leave the other unsecured creditors being forced into a plan of reorganization where they get far less than the secured creditors. Again, if that secured creditor is only of a single real estate asset, then the Subchapter V won't apply. But I think that secured creditors are probably going to do as well as they would do in any Chapter 11 case. Don't forget, there's still the rule that you can't get any less in a Chapter 11 case than you could get in a Chapter 7 liquidation. But I think if I'm to read into your question, I'm going to say that the unsecureds are going to do very badly, and or the debtor would have to take a longer time to pay them off and would have to make as best provision for the unsecureds as they can in the plan of reorganization. Any other questions? If not, I'm going to go through just a few pieces of the actual act. So again, the debtor in the act means a small business debtor. The debtor in possession means that the debtor continues to have the right to sign checks, hire, fire, breach executory contracts, decide which stores to close or not stores, just the same as in any other case. This next section talks about the US Trustee and when the US Trustee will and will not be appointed. There are provisions in the Act for removing the debtor in possession and for making sure and for providing the list of reasons. So the debtor in possession could be removed for cause, and cause would mean fraud, dishonesty, incompetence, gross mismanagement of the affairs of the debtor, either before or after the date of commencement of the case, or for any failure to perform the obligations of the debtor under a plan of reorganization to be confirmed. All of the assets of the company form part of the estate, and there is, if you notice, interestingly enough, an accrual kind of provision, which says that property includes earnings from services performed by the debtor after the date of commencement of the case, but before the case is closed, dismissed, or converted. So there is the ongoing need to have sales, cost of sales, and earnings, and all of that new money coming in is property of the estate. There is still monthly reporting requirements. There is still going to be a court status conference. Only the debtor can file a plan in the 90 days, and again, the court can extend the period. And this is what's going to go into the plan. It will be a history of the business, a liquidation analysis, because don't forget, in any Chapter 11 case, no creditor can get any less money or assets than it would have got in a liquidation. After all, what would be the point of a reorganization if the debtor would just, if the creditor would get simply just as much money as it would in a liquidation case? and then projections with respect to the ability of the debtor to make payments under the proposed plan of reorganization. So I think that this area here, these items here, the brief history of the operations of the debtor, the liquidation analysis, and the projections with respect to the ability of the debtor to make payments. I do think that those are areas that a professional could be hired to help the debtor. So again, when I first spoke to the Subchapter V trustee that I work with, he was in two minds, and here was his argument. On the one hand, he says he was perfectly capable himself of putting together and being paid for a brief history of the business operations of the debtor, the liquidation analysis, and the future projections if the debtor itself was not prepared or able to do that. However, the Subchapter V trustee that I spoke to conceded that there could be circumstances where not all of that was available, where it would have to be, forensically reconstructed. Part of what I do for this particular receiver/trustee is I often redo the accounting books and records. Part of what we do as a firm is rebuild incomplete and or falsified accounting books and records in order to come up with the true financial position of the entity. And I still think that with respect to a Subchapter V, that this is work that I could be doing again, notwithstanding that this is a small business and that they're trying to conserve and not pay administrative costs. Similarly, again, if this debtor owns any kind of unlisted investment in another entity, that would, I think, be an area where evaluation needs to be performed. Obviously, if it was a listed company, it didn't matter, but if it was unlisted, you need evaluation. And I think the other area is it's possible, even for a small business debtor in this day and age, to have intangible assets that may need to be valued. And again, I don't think I think that would fall outside of the capability of both the Subchapter V trustee and the debtor to make a valuation of any intangible assets. The plan is still going to be confirmed, and basically the plan talks about looking at all of the projected disposable income of the debtor to be received in the 3-year period or 5-year period, as the court may fix. So generally, this needs to be resolved in a 3 to 5 year period. So the plan of reorganization and the projections, unless the court and or creditors agree otherwise, it would still need the court's permission to go past the 3 or 5 year period, although the Act says not to exceed 5 years. So I don't know if the Bankruptcy Court has leeway. Disposable income would, income that is received by the debtor and not reasonably necessary to be expended for maintenance, domestic support obligations. So Again, like with the Bankruptcy Code, you cannot discharge your divorce, maintenance, child support, or domestic support obligations. So those have to be deducted before you pay disposable income. What's going to be interesting is sometimes maintenance and or child support in certain circumstances are often defined as a percentage of disposable income themselves. So maybe you're going to need a waterfall. You're going to have the disposable income of the debtor, on which you're then going to project and calculate maintenance or child support. And then you're going to have, if there's anything left, a remaining amount of disposable income for the creditors. This may well get into the need for a CPA valuation analyst or somebody with expertise, you know, in the case, perhaps in the underlying divorce case. You know, it's possible that a divorce case created the bankruptcy. I've seen that happen a lot. Usually, I see judgments against the company for lost litigation, lost profits cases, and things like that, also giving rise to the need for bankruptcy. There are provisions for the modification of the plan. There are provisions for transactions with professionals. So professionals are not excluded, although it remains to be seen whether or not professionals will be allowed. There's some additional discussion about these are all cross references to the original litigation, and Congress requires the effect on budgets, and that is what the material looks like. If anybody wants copies of the House reports or the congressional records, I have some, but not all. Again, a reminder, I do have a lot of accumulated materials on Subchapter 5 and the Small Business Reorganization Act of 2019. I'd be happy to help if anybody wants to email me. Also, if anybody actually wants to talk to a US trustee or the Subchapter 5 trustee that I work with, I would be very happy to facilitate an introduction. If anybody has any other questions, I'd be very happy to follow up and answer them after today's program. That does conclude my presentation, and I hope that everybody enjoys the rest of the conference.